Hi everyone, I'm Damon Wright with the Advertising and E-commerce Practice Group at GRSM. So, what did the FTC do in 2025 and why is that important? Well, if you want to avoid FTC enforcement action, you want to find out what they're enforcing against so you can not do that. Three main types of cases that we're seeing. One type of case, deceptive earnings claims. The FTC continues to go after businesses that are pitching money-making opportunities. These are companies that are saying we help businesses or people sell on Amazon, or we help people learn how to be an affiliate marketer, or maybe it's a multi-level marketing company, or some other business coaching. There was a case against Growth Cave where the FTC got an ex parte temporary restraining order and an asset freeze and a receiver appointed. Another case against a company called Click Profit. Again, FTC got an ex parte asset freeze and TRO with the receiver. There are cases against IM Mastery Academy. They paid $2.5 million to settle. There was a case against a company called Air AI and several others. The fix to avoid being one of these companies, the biggest thing you can do is to disclose what the track record, what's typical among the clients that are being served, either by a survey or if you have access to the data about their success, to disclose that. You can still spotlight the big winners and the most successful clients, but you need to highlight that they are the 90th percentile, the 95th percentile. Otherwise, the FTC will say, even if the claim is true that this person did this or that person did that, the claim is misleading because you haven't disclosed what's typical. Okay, another area that's a major enforcement priority, and it just is continuing, has to do with subscription billing and the federal law called the Restore Online Shoppers Confidence Act. It has three requirements. First, that there be a clear and conspicuous disclosure of the subscription billing terms. Second, that the consumer provide affirmative consent to those terms. And third, that there be a simple and easy mechanism to cancel the subscription. So there we saw a case against Clio, a cash advance company. They settled with the FTC paying $17 million. There's a case against Uber and their Uber One service that was filed by the FTC. A company called Paddle, a payment processor, was sued and paid $5 million. The allegation there was that they were supporting tech support merchants who were violating ROSCA and acted as the merchant of record there and were not complying with ROSCA. Match Group, that's the online dating service behind Match.com, OkCupid, Plenty of Fish. They were accused of violating ROSCA. They settled with payment of $14 million. A company called Chegg, an education tech provider, also sued and settled with the FTC, paying $7.5 million. Amazon and Amazon Prime paid $2.5 billion. Two executives with Amazon were also part of that case and part of the settlement. A company called Sendit, which is an anonymous messaging app, had an FTC case, mostly done with collection of children information, but they also were sued by the FTC under ROSCA. Instacart paid $60 million to settle with the FTC. Just last week, a company called Just Answer, this is in January, was sued for allegedly violating ROSCA in connection with this service that allows people to ask questions to experts, and it's like ask a lawyer on call.com, askwomenshealth.com. Also a company called Alleging Media, and there are a lot of related companies and individuals there. They were sued in 2024. In December, just a few weeks ago, the FTC started distributing money to consumers in connection with the settlement there and distributed $27.6 million. So some large dollars at stake with these FTC ROSCA cases. It's important to comply with that statute because there are also state laws that apply, and consumers can sue for violation of the state laws. They can't sue for violation of ROSCA, but we're seeing a lot of class action cases involving state subscription billing laws too. All right, third, there are cases involving testimonials and reviews, and we're going to see a lot more of these cases, I'm sure, because right now if you go onto TikTok or Instagram, there are just a flood of AI generated fake testimonials. Now again, advertising has to be true, not misleading, have reliable substantiation, and for a testimonial, that means the person talking about the benefits of this product has to be a real person, and they have to be describing their genuine experience with the product, and if they're being compensated at all, the business needs to disclose something like, we provided a token of appreciation in exchange for people sharing their story with us. But if you have a testimonial and it's not a real person, obviously that doesn't comply with the testimonial law. And there's going to be a lot of these cases, and they're going to, I think, make an example of some companies with fake testimonials and reviews. Fashion Nova settled a case, not that the reviews were fake, but they incentivized reviews according to the FTC. They also suppressed negative reviews from their website, and they paid $4.2 million last January. A company called NextMed, a GLP telemedicine company, also faced a lawsuit from the FTC concerning incentivizing positive reviews and allegedly fake before and afters in the photos displaying its products. I think this is going to be a major enforcement priority. The FTC issued a testimonial rule in October of 2024, and now they can get penalties of up to $53,000 per violation, which they're going to take to mean per fake testimonial or fake review, or review or testimonial where the compensation or connection wasn't disclosed. Just rounding this out, sweepstakes. One major case in the sweepstakes area was against Publishers Clearinghouse. Last April, they paid $18.5 million to settle their FTC case. That had to do with allegedly not disclosing the alternative means of entry in a proper way, that people could enter the sweepstakes without having to pay for anything, without having to buy anything. And lastly, just last week, the FTC announced that it's bringing a contempt motion against a payment processing company and a couple of its executives. That company is called Click, C-L-I-Q, and the issue there is they had a consent order in 2015, and the FTC saying the company and these executives did not comply with the consent order because they are continuing to support merchants who are on the match list or otherwise high risk, and the FTC says that they're helping merchants to avoid bank and credit card network fraud and risk monitoring programs. So that could have a ripple effect on the approach that other payment processors take. We sometimes hear that the match list is not a blacklist, but with a case like this, other payment processors could view it as a blacklist because they don't want to end up in the same situation as Click. The FTC is seeking $53 million in that case. So our goal as lawyers helping our clients is to help them make a lot of money, keep the money, and overall sleep well at night. Hope this was helpful towards those three goals, or that ultimate goal, and feel free to reach out if you'd like help. Take care. Bye-bye.